Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today.
So today on the podcast, we have one of my favorite criminal cases, R and Stinchcombe. And the reason I love this case is I heard it on another legal podcast, and I can't remember whose it is, and it'll probably come to me after we're done recording. But they were interviewing a lawyer about it, and they were discussing what Stinchcombe was about. And, you know, they asked the lawyer, what's your favorite case of all time? And the lawyer goes, The Queen and Stinchcombe. So do you want to tell us what Stinchcombe's about?
Yeah, so it is about Crown disclosure. If memory serves, I did read it, I promise. I just haven't read it in a while. But it is about Crown disclosure. So the Crown has to, correct me if I'm wrong, but the Crown has to disclose everything that they have in their possession that like could be relevant, and the bar is pretty high to show that it's not. Like they mostly have to disclose everything. Is that right?
Yeah, that's exactly it. And it's
Mostly.
interesting to think about because we kind of grown up in this time where like Crown disclosure, just a normal thing, right? You fill out a request, go to the Crown's office, pick up the disclosure. That's it. That was our summer at CLA for like defense work and
I was going to say,
POA, right?
You and me have opened many a CD-ROM. Yes, working for legal clinics. Yeah.
And the funny thing is, like when you read Stinchcombe, you had to ask the Crown for disclosure, and then the Crown could just decide what they gave you. So the Crown actually had the ability to surprise people at trial, which, when you think about it in like the big picture way, is like incredibly unfair.
Yeah. Because
the Crown has all of the time, all of the money, all of the information, and then they get to decide what they tell the defense and when.
Oh yeah.
So that's why Stinchcombe is so important.
Yeah, well, that's
it leveled the playing field.
Yeah, well, that gets into a lot of stuff about like power of the state, and that's putting crazy burdens on accused who would have less resources than other accused. And yeah, definitely like a huge access to justice, trial fairness issue for sure. Definitely.
Mm-hmm. And the court also, if I remember correctly, the court comments on the fact that there is no reverse like onus on the defense to disclose as well. It's just on the Crown, which again, if you think about in the big picture, it makes sense because the Crown, we discussed, like when you sue the government has unlimited resources.
Yes, definitely.
Right?
And yeah.
And defense doesn't.
Yeah, well, and it's like back to power of the state, right? Like it would seem strange that the person who the power of the state is being wielded against would have the same obligation of disclosure toward the state. Like that doesn't, it doesn't quite fit nice. So Stinchcombe definitely clarifies that. I also, now that I'm, memory is serving me, I remember this from the bar materials, which is fun because I thought I'd blacked that entire part of my life out already. But turns out this was also in the bar materials because I'm remembering it right now. So that's good. Something stuck. That's good.
Yeah, it's always funny when like the bar materials just kind of float their way back into your brain. You're like, oh wait, I actually learned this, which is always funny. But,
a very annoying, expensive ghost that just pops up from time to time and reminds you of things. So, yes, I answered an OBCA business question the other day at work, and I felt very smart, and I had to thank my bar materials because I certainly did not know any of that like 4 months ago. So,
yeah,
I did learn something.
Definitely.
But yeah, no, we sort of worked for places that are on both sides of this disclosure situation, and it's definitely something that comes up. And I would suspect sort of now in our COVID, post-COVID, currently still COVID world, disclosure is going to come up all over again in new ways in terms of like form, because I know a lot of government offices are still operating on older technology, and I bet we see soonish rather than later disclosure issues around the Crown coming up in terms of what the Crown is disclosing things on and how they're disclosing it.
Yep. And that also brings up, bringing it back to access to justice. For right now, disclosure is mostly done on paper or on CD or on a USB thumb drive. And you have to physically attend an office to get it. So there might be changes coming one day in the future where maybe disclosure is done digitally somehow through maybe like an online portal or something like that. Who knows? But I think Stinchcombe is one of those cases that just it'll stand the test of time, and I don't think this is one of those things that'll ever be changed.
No,
because it sets the law so flat out and clear.
Oh yeah, maybe updated for the times, but definitely not overturned, I don't think. But Who knows?
Definitely not. Well, guys, that's our brief intro on the bar materials and Stinchcombe. So I hope you enjoy the reading of this one. The Queen and Stinchcombe. The judgment of the court was delivered by Justice Sopinka. This appeal raises the issue of the Crown's obligation to make disclosure to the defense. A witness who gave evidence at the preliminary inquiry favorable to the accused was subsequently interviewed by agents for the Crown. Crown Counsel decided to not call the witnesses and would not produce the statements obtained at the interview. The trial judge refused an application by the defense for disclosure on the grounds that there was no obligation on the Crown to disclose the statements. The Court of Appeal affirmed the judgment at trial, and the case is here with leave of this court. 1. Facts. The appellant was a Calgary lawyer charged with appropriating certain financial instruments from a client, one Jack Abrams. The indictment charged 13 counts of criminal breach of trust contrary to Section 296 of the Criminal Code, now Section 336, 13 counts of theft contrary to Section 294A, now Section 334A of the Code, and 1 count of fraud contrary to Section 3381A, now Section 3801A of the Code. The trial in the Alberta Court of Queen's Bench was before Brennan J. without a jury. The Crown alleged that the appellant had wrongfully appropriated property which he held in trust for Abrams. The defense did not contest the receipt of funds by the appellant. The defense did contend, however, that despite Stinchcombe's formal status as a trustee of the property, Abrams had in fact made Stinchcombe his business partner. Under this theory, Stinchcombe had acted how he was legally entitled to act. At issue, therefore, was the actual, as opposed to the formal, nature of the relationship between the two men. Patricia Lineham is a former secretary of Mr. Stinchcombe. She was a Crown witness at the preliminary inquiry. There, she gave evidence to which was, apparently, very favorable to the defense regarding the conduct of Abrams. The precise content of this testimony was not before the trial judge and is not in the record. Lineham was not listed on the indictment, but was subpoenaed by the Crown. After the preliminary inquiry, but prior to the trial, Lineham was interviewed by an RCMP officer. A tape-recorded statement was taken. Crown Counsel informed defense counsel of the existence but not the content of this statement. A request for disclosure was refused. Later, during the course of the trial, Lineham was again interviewed by a police officer and a written statement was taken. Again, though defense counsel was advised of the existence of the statement, a request for disclosure was refused. Crown Counsel also indicated that he would not be calling Lineham as she was not worthy of credit. It was not until the third day of the trial that the defense counsel learned conclusively that Lineham would not be called by the Crown. At this time, he moved before the trial judge for an order that 1. The Crown call the witness, or 2. The court call the witness, or 3. The Crown disclose the contents of the statements to the defense. A review of the record makes it clear that defense counsel was pressing for access to, or production of, both the tape-recorded and written statements and was not pressing the alternative requests. In support of this motion, counsel for the defendant indicated that Miss Lineham refused to speak to him or his staff when they attempted to interview her about the contents of the statements. Crown Counsel did not provide any basis for resisting the production other than to say that, in his view, the potential witness was not worthy of credit. The trial judge dismissed the application. Brennan J. ruled that under the circumstances, there was no obligation on the Crown to call the witness, and there was no obligation on the Crown to disclose the contents of the statements. The trial proceeded, and the accused was found guilty of all 27 counts charged. A conditional stay was entered with respect to the 13 theft counts. The Alberta Court of Appeal dismissed the appeal from conviction without issuing reasons. Leave to appeal to this court was granted on the disclosure issue. During argument before this court, an application was made by the Crown to adduce the statements and tape as fresh evidence. This application was rejected. The principal basis for the rejection was that at this stage it would be impossible to determine whether the statements would have been material to the defense if produced at trial. 2. Crown's obligation to disclose. The circumstances which give rise to this case are testimony to the fact that the law with respect to the duty of Crown to disclose is not settled. A number of cases have addressed some aspects of this subject. See, for example, Cunliffe and Law Society of British Columbia, Savian and the Queen in Bourget, No case in this court has made a comprehensive examination of this subject. The Law Reform Commission of Canada, in a 1974 working paper titled Criminal Procedure Discovery, aka the 1974 working paper, and a 1984 report titled Disclosure by the Prosecution, aka the 1984 report, recommended comprehensive schemes regulating disclosure by the Crown, but no legislative action had been taken implementing these proposals. Apart from the limited legislative response contained in Section 603 of the Criminal Code, enacted in the 1953-54 overhaul of the Code, which itself condensed pre-existing provisions, legislators had been content to leave the development of the law in this area to the courts. Production and discovery were foreign to the adversary process of adjudication in its earlier history, when the element of surprise was one of the accepted weapons in the arsenal of the adversaries. This applied to both criminal and civil proceedings. Significantly, in civil proceedings, this aspect of the adversary process has long since disappeared, and full discovery of documents and oral examination of parties, and even witnesses, are familiar features of the practice. This change resulted from the acceptance of the principle that justice was better served when the element of surprise was eliminated from the trial, and the parties were prepared to address issues on the basis of complete information of the case to be met. Surprisingly, in many criminal cases in which the liberty of the subject is usually at stake, this aspect of the adversary system has lingered on. While the prosecution bar has generally cooperated in making disclosure on a voluntary basis, there has been considerable resistance to the enactment of comprehensive rules which would make the practice mandatory. This may be attributed to the fact that the proposals for reform in this regard do not provide for reciprocal disclosure by the defense. See the 1974 working paper, the 1984 working paper, and the Marshall Commission report. It is difficult to justify the position which clings to the notion that the Crown has no legal duty to disclose all relevant information. The arguments against the existence of such a duty are groundless, while those in favor are, in my view, overwhelming. The suggestion that the duty should be reciprocal may deserve consideration by this court in the future, but it is not a valid reason for absolving the Crown of its duty. The contrary contention fails to take account of the fundamental differences in the respective roles of the prosecution and the defense. In Boucher and the Queen, Justice Rand states, "It cannot be overemphasized that the purpose of a criminal prosecution is not to obtain a conviction. It is to lay before a jury what the Crown considers to be credible evidence relevant to what is alleged to be a crime. Counsel have a duty to see all available legal proof of the facts is presented. It should be done firmly and pressed to its legitimate strength, but it must also be done fairly." The role of the prosecutor excludes any notion of winning or losing. His function is a matter of public duty, that which in civil life there can be none charged with greater personal responsibility. It is to be efficiently performed with an ingrained sense of the dignity, the seriousness, and the justness of judicial proceedings. I would add that the fruits of the investigation, which are in the possession of the counsel for the Crown, are not the property of the Crown for use in securing a conviction, but the property of the public to be used to ensure that justice is done. In contrast, the defense has no obligation to assist the prosecution and is entitled to assume a purely adversarial role towards the prosecution. The absence of a duty to disclose can, therefore, be justified as being consistent with this role. Other grounds advanced by advocates of the absence of a general duty to disclose all relevant information are that it would impose onerous new obligations on the Crown prosecutors, resulting in increased delays in bringing the accused persons to trial. This ground is not supported by the material in the record. As I have already observed, disclosure is presently being made on a voluntary basis. The extent of disclosure varies from province to province, from jurisdiction to jurisdiction, and from prosecutor to prosecutor. The adoption of uniform, comprehensive rules for disclosure by the Crown would add to the workload of some Crown counsel, but this would be offset by the time saved which is now spent resolving disputes, such as this one, surrounding the extent of the Crown's obligation and dealing with matters that it take to the defense by surprise. In the latter case, an adjournment is frequently the result of non-disclosure, or more time is taken by a defense counsel who is not prepared. There is also compelling evidence that much time would be saved and therefore delays reduced by reason of the increase in guilty pleas, withdrawal of charges, and shortening or waiver of preliminary hearings. The 1984 report refers to several experimental projects which were established after the publication of the 1974 working paper in order to test the viability of pretrial disclosure. The result of these experiments, and in particular the Montreal experiment, which was the most exhaustively evaluated, was that there was a significant increase in the number of cases settled and pleas of guilty entered or charges withdrawn. In England, under the provisions of the Criminal Justice Act of 1967, a packet of material is furnished to defense counsel. The provision of such material has led to a reduction in the length and number of preliminary hearings in that jurisdiction. See Report of the Special Committee on Preliminary Hearings, Bench and Bar Council of Ontario. Refusal to disclose is also justified on the ground that the material will be used to enable the defense to tailor its evidence to conform with the information in the Crown's possession. For example, a witness may change his or her testimony to conform with a previous statement given to the police or counsel for the Crown. I am not impressed with this submission. All forms of discovery are subject to this criticism. There is surely nothing wrong in a witness refreshing his or her memory from a previous statement or document. The witness may even change his or her evidence as a result. This may rob the cross-examiner of a substantial advantage, but fairness to the witness may require that a trap not be laid by allowing the witness to testify without the benefit of seeing contradictory writings which the prosecutor holds close to the vest. This principle has been accepted that the search for truth is advanced rather than retarded by disclosure of all relevant material. Finally, it is suggested that the disclosure may put at risk the security and safety of persons who have provided the prosecution with information. No doubt measures must be occasionally taken to protect the identity of witnesses and informers. Protection of the identity of informers is covered by the rules relating to informer privilege and exceptions thereto. See Marks and Bafis. And any rules with respect to disclosure would be subject to this and other rules of privilege. With respect to witnesses, persons who have information that may be evidence favorable to the accused will have to have their identity disclosed sooner or later. Even the identity of an informer is subject to this fact of life by virtue of the innocence exception to the informer privilege rule. See Marks and Bafis, as well as the Queen and Scott, Baselin and Keeble, and the Solicitor General of Canada and the Royal Commission of Inquiry, Health Records in Ontario. It will, therefore, be a matter of the timing of the disclosure rather than whether the disclosure should be made at all. The prosecutor must retain a degree of discretion in respect of these matters. The discretion, which will be subject to review, should extend to such matters as excluding what is clearly irrelevant, withholding the identity of persons to protect them from harassment or injury, or to enforce the privilege relating to the informers. The discretion would also extend to the timing of disclosure in order to complete an investigation. I shall return to this subject later in these reasons. This review of the pros and cons with respect to the disclosure by the Crown shows there is no valid practical reason to support the position of the opponent of a broad duty of disclosure. Apart from the practical advantages to which I have referred, there is the overriding concern that the failure to disclose impedes the ability of the accused to make full answer in defense. This common law right has acquired new vigor by virtue of its inclusion into Section 7 of the Canadian Charter of Rights and Freedoms as one of the principles of fundamental justice. The right to make full answer in defense is one of the pillars of criminal justice on which we heavily depend to ensure that the innocent are not convicted. Recent events have demonstrated that the erosion of this right due to non-disclosure was an important factor in the conviction and incarceration of an innocent person. In the Royal Commission on the Donald Marshall Jr. Prosecution, Volume 1, Findings and Recommendations, also known as the Marshall Commission Report, the commissioners found that the prior inconsistent statements were not disclosed to the defense. This was an important contributing factor in the miscarriage of justice which occurred and led to the commission to state that anything less than complete disclosure by the Crown falls short of decency and fair play. The commission recommended an extensive regime of disclosure, of which the key provisions are as follows. 2. Sub 1. Without request, the accused is entitled, before being called upon to elect the mode of trial or plead to the charge of an indictable offense, whichever comes first, and thereafter, A. To receive a copy of his criminal record, B. To receive a copy of any statement made by him to a person in authority and recorded in writing, or to inspect such a statement if it has been recorded by electronic means, and to be informed of the nature and content of any verbal statement alleged to have been made by the accused in a person of authority, and to be supplied with any memorandum in existence pertaining hereto. C. To inspect anything that the prosecutor proposes to introduce as an exhibit and, where practicable, receive copies thereof. D. To receive a copy of any statement made by a person whom the prosecutor proposes to call as a witness, or anyone who may be called as a witness, and recordings in writing, or, in the absence of a statement, a written summary of the anticipated testimony of the proposed witness, or anyone who may be called as a witness. E. To receive any other material or information known to the Crown, and which tends to mitigate or negate the defendant's guilt as to the offense charged, or which would tend to reduce his punishment therefore, notwithstanding that the Crown does not intend to introduce such material or information as evidence. F. To inspect the electronic recordings of any statement made by a person to whom the prosecutor proposes to call as a witness. G. To receive a copy of the criminal record of any proposed witness. And H. To receive, where not protected from disclosure by the law, the name and address of any other person who may have information useful to the accused, or other details enabling that person to be identified. 2. Sub 2. The disclosure contemplation in Section 1, paragraph D, E, and H, shall be provided by the Crown and may be limited only where, upon an inter partes application by the prosecutor, supported by evidence showing a likelihood that such disclosure will endanger the life or safety of such person or interfere with the administration of justice, a justice having jurisdiction in the matter deems it just and proper. In my opinion, there is a wholly natural evolution of the law in favor of disclosure by the Crown of all relevant material. As long ago as 1951, Justice Cartwright stated in LeMay and the King, "I wish to make it perfectly clear that I do not intend to say anything which might be regarded as lessening the duty which rests upon counsel for the Crown to bring forward evidence of every material fact known to the prosecution, whether favorable to the accused or otherwise." This statement may have been in a reference to the obligation resting on counsel for the Crown to call evidence rather than to disclose the material to the defense, but I see no reason why this obligation should not be discharged by disclosing the material to the defense rather than obligating the Crown to make it a part of the Crown's case. Indeed, some of the information will be in a form that cannot be put into evidence by the Crown, but can be used by the defense in cross-examination or otherwise. Production to the defense is then the only way in which the injunction of Justice Cartwright can be obeyed. In the Queen and CMH, Justice McEaron, after a review of the authorities, stated that I respectfully accept as a correct statement of the law. He said that there is a general duty on the part of the Crown to disclose all material it proposes to use in trial, and especially all evidence which may assist in the accused, even if the Crown does not propose to adduce it. This passage was cited with approval by McLaughlin J. in her reasons on behalf of the Court. She went on to add, "This Court has previously stated that the Crown is under a duty at common law to disclose to the defense all material evidence whether favorable to the accused or not." As indicated earlier, however, this obligation to disclose is not absolute. It is subject to the discretion of counsel for the Crown. This discretion extends to both the withholding of information and to the timing of disclosure. For example, counsel for the Crown has a duty to respect the rules of privilege. In the case of informers, the Crown has a duty to protect their identity. In some cases, serious prejudice or even harm may result to a person who has supplied evidence or information to the investigation. While it is a harsh reality of justice that ultimately any person with relevant evidence must appear to testify, the discretion extends to the timing and manner of disclosure in such circumstances. A discretion must be exercised with respect to the relevance of the information. While the Crown must err on the side of inclusion, it need not produce what is clearly irrelevant. The experience to be gained from the civil side of the practice is that counsel, as officers of the court and acting responsibly, can be relied upon not to withhold pertinent information. Transgressions with respect to this duty constitute a very serious breach of legal ethics. The initial obligation to separate the wheat from the chaff must therefore rest with Crown counsel. There may also be situations in which early disclosure may impede completion of an investigation. Delayed disclosure on this account is not to be encouraged and should be rare. Completion of the investigation before proceeding with the prosecution of a charge or charges is very much within the control of the Crown. Nevertheless, it is not always possible to predict the events which may require an investigation to be reopened, and the Crown must have some discretion to delay disclosure in these circumstances. The discretion of Crown Counsel is, however, reviewable by the trial judge. Counsel for the defense can initiate a review when an issue arises with respect to the exercise of the Crown's discretion. On a review, the Crown must justify its refusal to disclose. Insomuch as disclosure of all relevant information is the general rule, the Crown must bring itself within a reasonable exception to that rule. The trial judge may also review the Crown's exercise of discretion as to the relevance and the interference with the investigation to ensure that the right to make full answer and defense is not violated. I am confident that disputes over disclosure will arise infrequently when it is made clear that the counsel for the Crown is under a general duty to disclose all relevant information. The tradition of Crown Counsel in this country in carrying out their role as ministers of justice, and not as adversaries, has generally been very high. Given this fact, and the obligation on defense counsel as officers of the court to act responsibly, these matters will usually be resolved without the intervention of the trial judge. When they do arise, the trial judge must resolve them. This may require not only submissions, but the inspection of statements and other documents, and indeed, in some cases, viva voce evidence. A voir dire will frequently be the appropriate procedure in which to deal with these matters. Counsel for the accused must bring to the attention of the trial judge at the earliest opportunity any failure of the Crown to comply with its duty to disclose, of which counsel becomes aware. Observance of this rule will enable a trial judge to remedy any prejudice to the accused if possible, and thus avoid a new trial. See Cacamau and the Queen. Failure to do so by counsel for the defense will be an important factor in determining on appeal whether a new trial should be ordered. These are general principles that govern the duty of the Crown to make disclosure to the defense. There are many details with respect to their application that remain to be worked out in the context of concrete situations. It would neither be possible nor appropriate to attempt to lay down precise rules here. Although the basic principles of disclosure will apply across the country, the details may vary from province to province and even within a province by reason of special local conditions and practices. It would, therefore, be useful if the underutilized power conferred by Section 482 of the Criminal Code, which empowers superior courts in courts of criminal jurisdiction to enact rules where employed to provide further details with respect to the procedural aspects of disclosure. The general principles referred to herein arise in the context of indictable offenses. While it may be argued that the duty of disclosure extends to all offenses, many of the factors which I have canvassed may not apply at all or may apply with less impact in summary conviction offenses. Moreover, the content of the right to make full answer and defense entrenched in Section 7 of the Charter may be of a more limited nature. A decision as to the extent to which the general principles of disclosure extend to summary conviction offenses should be left to a case in which the issue arises in such a proceeding. In view of the number and variety of statutes which create such offenses, consideration would have to be given as to where to draw the line. Pending a decision on that issue, the voluntary disclosure, which has been taking place through a cooperation of Crown Counsel, will no doubt continue. Continuation and extension of this practice may eliminate the necessity for a decision on the issue by this court. There are, however, two additional matters which require further elaboration of the general principles of disclosure outlined above. They are 1. The timing of the disclosure, and 2. What should be disclosed. Some detail with respect to these issues is essential if the duty to disclose is to be meaningful. Moreover, with respect to the second matter, resolution of the dispute over disclosure in this case requires a closer examination of the issue. With respect to timing, I agree that the recommendation of the Law Reform Commission of Canada in both of its reports that initial disclosure should occur before the accused is called upon to elect the mode of trial or to plead. These crucial steps which the accused must take which affect his or her rights in a fundamental way. It will be of great assistance to the accused to know that there are strengths and weaknesses of the Crown's case before committing on these issues. As I've pointed out above, the system will also profit from early disclosure, as it will foster the resolution of many charges without trial through increased number of withdrawals and pleas of guilty. The obligation to disclose will be triggered by a request or on behalf of the accused. Such a request may be made at any time after the charge. Provided that the request for disclosure has been timely, it should be complied with so as to enable the accused sufficient time before election or plea to consider the information. In the rare cases in which the accused is unrepresented, Crown Counsel should advise the accused of the right to disclosure, and a plea should not be taken unless the trial judge is satisfied that this has been done. At this stage, the Crown's brief will often not be complete and disclosure will be limited by this fact. Nevertheless, the obligation to disclose is a continuing one, and disclosure must be completed when additional information is received. With respect to what should be disclosed, the general principle to which I have referred is that all relevant information must be disclosed, subject to the reviewable discretion of the Crown. The material must include not only which the Crown intends to introduce into evidence, but also which it does not. No distinction should be made between inculpatory and exculpatory evidence. The attempt to make this distinction in connection with the confession rule proved to be unworkable and was eventually discarded by this court. See Pichet and the Queen and Rothman and the Queen. To reintroduce the distinction here would lead to the indeterminable controversy at trial that should be avoided. The Crown must, therefore, disclose relevant material whether it is inculpatory or exculpatory. A special problem arises in respect to witness statements and is specifically raised in the case. There is virtually no disagreement that the statements in the possession of the Crown obtained from witnesses it proposes to call should be produced. In some cases, the statement will simply be recorded in notes taken by an investigator, usually a police officer. The notes or copies should be produced. If notes do not exist, then a will say statement summarizing the anticipated evidence of the witness should be produced based on the information in the Crown's possession. A more difficult issue is posed with respect to witnesses and other persons whom the Crown does not propose to call. In its 1974 working paper, the Law Reform Commission of Canada recommended disclosure of not only the names, addresses, and occupations of all persons who have provided information to investigation or prosecution authorities, but of statements obtained, or, if the statements did not exist, a summary of the information provided by these persons not intended to be called at trial, along with the statement of the manner in which the information in each summary has been obtained. In its 1984 report, the Commission seemed to have changed its mind. It stated, "With respect to potential witnesses, we do not recommend, on a mandatory basis, the type of thorough disclosure that we recommended with respect to proposed witnesses. Complete disclosure would entail not only the identification of such persons, but the disclosure of any statement they made and, in some cases, their criminal records. In our view, a recommendation to this effect would be excessive and disproportionate to the needs of the defense. In many instances, these people are of no use, or of marginal use, to the case for either side. Their statements are not evidence, although they may be effectively used by the prosecution for purposes of impeachment and cross-examination in the event the witness is called by the accused. Prosecutors are understandably reluctant to disclose these statements because to do so would imperil their principal utility. It is our view that the interests of the defense are adequately served by the mandatory disclosure of the identity of such persons, although we would not wish our comments to discourage prosecutors from disclosing statements and other relevant information on a voluntary basis. The Marshall Commission report recommended disclosure of any statement made by a person whom the prosecution proposes to call as a witness, or anyone who may be called as a witness. Although not entirely clear, this recommendation appears to extend to anyone who has relevant information and who is either compellable or prepared to testify whether proposed to be called by the Crown or not. This court in the Queen and CMH, Supra, dealt with the failure to disclose either the identity or statement of a person who provided relevant information to the police but was not called as a witness. Justice McLaughlin, speaking for the court, indicated that failure to disclose in such cases could impair the fairness of the trial. I am of the opinion that, subject to the discretion to which I referred above, all statements obtained from persons who have provided relevant information to the authorities should be produced, notwithstanding that they are not proposed as Crown witnesses. Where statements are not in existence, other information such as notes should be produced, and, if there are no notes, then in addition to the name, address, and occupation of the witness, all information in the possession of the prosecution relating to any relevant evidence that the person could give should be supplied. I do not find the comments of the Commission in its 1984 report persuasive. If the information is of no use, then presumably it is irrelevant and will be excluded in the exercise of the discretion of the Crown. If the information is of some use, then it is relevant, and the determination as to whether it is sufficiently useful to put into evidence should be made by the defense and not the prosecutor. Moreover, I do not understand the Commission's statement that their statements are not evidence. This is true of all witness statements. They themselves are not evidence, but are produced, not because they will be put into evidence in that form, but will enable the evidence to be called viva voce. That prosecutors are reluctant to disclose statements because use of them in cross-examination is thereby rendered less effective is understandable. That is an objection to all forms of discovery and disclosure. Tactical advantage must be sacrificed in the interests of fairness and the ascertainment of the true facts of the case. 3. Application to this case. No request was made in this case for disclosure prior to pleading or electing the mode of trial, and this issue does not, therefore, arise. A request for disclosure was made during the trial for the disclosure of 2 statements taken subsequent to the preliminary hearing. An application for disclosure was dismissed by the trial judge on the ground that there was no obligation on the Crown to disclose the statements. Applying the above principles, I conclude that the following errors were committed. 1. Counsel for the Crown misconceived his obligation to disclose the statements. 2. The explanation for refusal that the witness was not worthy of credit was completely inadequate to support the exercise of this discretion on the ground of irrelevance. Whether the witness is credible is for the trial judge to determine after hearing the evidence. 3. The trial judge ought to have examined the statements. The suggestion that this would have prejudiced the trial judge is without merit. Trial judges are frequently apprised of such evidence which is ruled inadmissible. One example is a confession that fails to meet the test of voluntariness. No one would suggest that knowledge of such evidence prejudices the trial judge. We operate on the principle that a judge trained to screen out inadmissible evidence will disabuse him or herself of such evidence. 4. The trial judge erred in his statement of the duty to disclose on the part of the Crown. It was submitted that the appellant was not deprived of the opportunity to make full answer in defense because he could have a. interviewed the witnesses and obtained his own statements, or b. called the witness, and if her evidence was proved adverse, cross-examined on the basis of the preliminary hearing transcript. With respect to a, counsel for the appellant pointed out that the witness refused to be interviewed. In any event, if such an interview took place, what the witness said on 2 prior occasions would be very material to the defense. As for B, counsel for the defense is entitled to know whether the witness he/she is calling will give evidence that will assist the defense or whether the witness will be adverse and necessitate an application to cross-examine on the basis of a prior inconsistent statement. The latter usually creates an undesirable atmosphere at the trial, and the most that can be achieved is to impeach or destroy the credibility of the witness. See McInroy and the Queen and Manian. Most counsel faced with this prospect would likely opt to not call the witness, a matter which bears on the right to make full answer in defense. What are the legal consequences flowing from a failure to disclose? In my opinion, when a court of appeal is called upon to review a failure to disclose, it must consider whether such failure impaired the right to make full answer in defense. This in turn depends on the nature of the information withheld and whether it might have affected the outcome. See Justice McLaughlin in the Queen and CMH. Had counsel for the appellant been aware of the statement, he might have well decided to use it in support of the defense that the evidence of the complainant was a fabrication. In my view, the evidence would conceivably have affected the jury's conclusion on the only real issue, the respective credibility of the complainant and the appellant. In this case, we are told that the witness gave evidence at the preliminary hearing favorable to the defense. The subsequent statements were not produced, and therefore, we have no indication from the trial judge as whether they were favorable or unfavorable. Examination of the statements, which were tendered as fresh evidence in this court, should be carried out at trial so that counsel for the defense, in the context of the issue in the case and other evidence, can explain what use might be made of them by the defense. In the circumstances, we must assume the non-production of the statements was an important factor in the decision not to call the witness. The absence of this evidence might very well have affected the outcome. Accordingly, I would allow the appeal and direct a new trial at which the statement should be produced.
Legal Listening is founded by Zach Battiston and Carly Lyons. Hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radamile. Audio engineering by Anthony Radamile. Graphic design by Julie Lundy at julielundyart.com. Music by Matt Radamile at radandkel.com. We're always open to ideas, suggestions, and of course, guest readers. Check us out at Legal Listening on Twitter and at legallistening.com. We'll talk to you next time.